Hi, I'm Gwendolyn Sterk of Sterk Family Law, and I'm privileged to have with me today Terrence Fogarty of Sterk Family Law as well for purposes of estate plan. Thanks for talking to me today.
Sure, Gwen.
And we want to talk today about guardianships because we seem to be getting an uptake in this. Just as a general rule of thumb, there are two types of guardianships. Can you explain the different types?
Sure. There's a guardianship of the person and a guardianship of the estate. And basically, it's pretty much exactly how it sounds. A guardianship of the person is for an individual who really can't make decisions in their everyday care. So they have limitations in taking care of themselves and in how they basically get through their everyday life. And then a guardianship of the estate has to do with their finances basically every aspect of everything that they own.
Sure. And then depending on your age, there are different types of guardianships, meaning there can be guardianship of a minor or guardianship of a disabled adult, correct?
Correct. And guardianship of a disabled adult obviously is in case when a person cannot make decisions for themselves, either about their care or about their finances. Guardianship of a minor is a little more statutory, of course, because a minor needs somebody to take care of them.
Right.
Oftentimes that is appointed by as their guardian.
Right, and so for example, if a parent's not available and a grandparent or someone else needs to take care of the child, you can step in those situations and apply to the court to be able to be that guardian, correct?
That's correct.
And so that's one area which is dependent and very fact-specific to the availability of the parents, who would have to be notified, and the parents would either consent or the court could appoint the guardianship, correct?
That's correct. It is very fact-specific as far as how you plan on taking care of the child, why you are the best choice to take care of the child. The court's going to look at all of that because they really don't want to take parental rights away from somebody else if that person is available.
Correct. And then there's also forms available under the statute that up to a year you can do a temporary guardianship. So for example, if there's a situation where someone's ill or someone's out of the country for a period of time, and that might be a remedy as well, correct?
Correct.
And so the best way for someone to look at that situation is to really schedule a consultation with our office, because then you can go through the options about what their options are with regard to the minor, correct?
Exactly, because it is very fact-specific.
And then when you do the estate planning, you also would be naming, for example, if parents are creating a will, who they would have as a preference for the guardian.
Yes, that's correct.
And so then if parents are divorced, there gets into certain situations and certain rights that might be incident to that. So that's one area that we cover within our structure here at Sterk Family Law. The other is what we see an uptake on, which is really guardianship for that disabled adult.
Yes.
And that can involve both. An example is someone who has a special needs child. And so once they reach the age of 18, why is it important to get the guardianship?
Well, it's important to get the guardianship because now they are an adult for all intents and purposes. So they do have certain rights under the law, and you as their guardian would basically be ensuring that they're being taken care of properly.
Right, and we try to do that as close to the 18th birthday as possible, because at the 18th birthday, for purposes of our probate act, they would become an adult, correct?
Correct.
So if you have a disabled adult or a disabled child, for example, you're not going to be able to make those medical decisions once they turn 18 unless you put in process a remedy.
That's correct. You could really find yourself in a very difficult situation if you haven't started the process prior to their 18th birthday.
Sure. Then we get into the other situation where we have either adult children or you have a spouse and you need to be able to then get a guardianship to be able to make decisions for them because they're not capable of making decisions anymore. You can avoid that process perhaps by doing some pre-planning. Is that correct?
You can avoid that process by obtaining certain powers of attorney for that individual while they have the capacity to make those decisions.
Sure.
You can really avoid a guardianship in all aspects if you do the proper type of planning. There are obviously certain circumstances that come up where a guardianship's just the only thing that's available.
Sure.
But you can really plan around it.
But if you are in that situation where you haven't planned around it, so all of a sudden you're seeing memory loss, you're seeing dementia, Alzheimer's, some type of alcohol syndrome that's occurred, a car accident can result in this. Then your remedy is to hire an attorney and then you fill out the paperwork to do the guardianship, correct?
That's correct. There are a lot of I get a lot of phone calls from folks who say, you know, my parents are getting up there, they've got dementia, I really need to get their estate plan taken care of, and a lot of times it's a little bit too late at that point because they don't have the capacity to make those estate planning decisions.
Correct.
So guardianship does become another viable option.
Now, when you do a guardianship, you have to get a report of the physician. Can you tell us why that's a necessary step?
Yes, basically the court does not want to grant a guardianship and take away an individual's rights and ability to care for themselves unless it's absolutely necessary. You really have to prove by clear and convincing evidence that you need that guardianship over that individual. So the main reason that they want to see that physician's report is so that they can see that they have been examined by a doctor and the doctor has adjudged them incapable of taking care of themselves.
Sure. And then the guardian or the ward, meaning the person that is going to be, you know, decisions are going to be made for that person. That becomes the ward, correct?
Correct.
And the ward can then go back to court, true, to kind of contest at the beginning or at any stage to say, I want that guardianship removed.
That's correct. A lot of times we see that certain circumstances are temporary. So they can contest it in the beginning and they can say, no, I do not need this type of guardianship. And the court can either decide that they're correct and they don't need the guardianship, they can decide that they're incorrect and they do need a guardianship, or they can provide for a limited guardianship for certain items to be taken care of. And then if that condition that's caused them to be incapable of making decisions does clear up later down the road, the ward can petition the court to remove the guardianship.
Perfect. And then when we talk about guardianships of the estate, that's really controlling the financial aspects.
Correct.
And by controlling the financial aspects, I just want to make it clear, is that that person has what we call in law a fiduciary responsibility to the ward's assets. Can you explain what that means?
Sure. A fiduciary duty basically means that you have a duty to take care of their finances the way that you take care of your own. And frankly, you have a duty to them to make sure that every decision you make is in their best interest.
Correct. So if you're in that situation and you're finding that a guardianship is something that's necessary either of a minor or of a disabled adult, you can call our office. You give free consultations, correct?
That's correct.
And then you can navigate through the different options that might be available. And also, if you are anticipating this as a family situation or you're doing some pre-planning, you might want to look at this in the context of your estate plan to avoid this court litigation process if it can be avoided, correct?
Yes, definitely.
So these are the options that are available, something seriously to take into mind and make sure that we're taking care of business. I'm all about that. Take care of business. That's our message to our folks today, correct?
Yes, that's correct.
Thank you so much.
Thank you, Gwen.